Welcome, everybody. I want to welcome you. The reason I'm rushing a little bit is because we have two fabulous speakers, and I want to make sure to give as much time as possible, not only to what they have to say, but to your Q&A. So I am Wendy Schiller. I'm the Interim Director of the Watson Institute for International and Public Affairs and the Director of the Taubman Center for American Politics and a professor, the Alison S. Ressler Professor of Political Science. I will be transitioning out of this role happily and going on sabbatical, and Watson will be a school of international and public affairs as of July 1st. We're very excited about this transition. It's a great step for Brown. Professor John Friedman from the Economics Department will be stepping in as the inaugural dean of the school. He apologizes for not being here. It's Memorial Day. He had prior family obligations. And we're very happy that Professors Corey Brettschneider and Michael Vorenberg managed to negotiate with their families, some of whom are here, to be here. So this is going to be absolutely fabulous. I'm going to get right to it. I do want to say that Brown does have a core free speech policy. We encourage absolute free speech here, but we also have a policy that says that you cannot disrupt or block or basically try to thwart any other speaker during a public event. So I'm hopeful that we'll all be able to engage in a way that is productive for everybody. And I also like to thank all of the parents and grandparents for producing such fabulous children. It is an absolute privilege and honor to teach at Brown. It is like winning the academic lottery to work here, and we're all thrilled to have that honor. I will do the quick promo. I'm going to start with Corey Brettschneider, whose most recent book, his prolific author. I'll do his bio in a second. The President and the People. Five leaders who threatened democracy and citizens who fought to defend it. It's a fabulous new book, and we'll be talking a little bit about that today. And Professor Michael Vorenberg, whose book, Lincoln's Peace, The Struggle to End the American Civil War. I can genuinely say I don't think there's anybody at Brown or anywhere else that knows more about Abraham Lincoln and the Civil War than Michael Vorenberg. So we are very fortunate to have both of them here today. So, bio. Corey Brettschneider is professor of political science at Brown University, where he teaches constitutional law and political theory. He is the author of The Presidents and the People, 5 Leaders Who Threatened Democracy and the Citizens Who Fought to Defend It, which recently won the Silver Gavel Book Award from the American Bar Association. He is also the co-host of the new podcast, The Oath in the Office, a weekly look at the politics of the presidency and the Supreme Court. The podcast takes its name from a book of the same name, which Kirk has called Vital Reading for All Americans. His other books include When the State Speaks, What Should It Say? How Democracies Can Protect Expression and Promote Equality, Princeton University Press, and Democratic Rights, The Substance of Self-Government, Princeton University Press. Professor Brettschneider's writings have appeared in The Guardian, The New York Times, Politico, and The Washington Post. He holds a PhD in politics from Princeton and a JD from Stanford Law School. Professor Michael Vorenberg, who's most recently promoted to full professor, congratulations to Michael Vorenberg, is a professor of history at Brown University, where he teaches courses on the Civil War and Reconstruction, as well as American legal and constitutional history. He is the author, most recently, of Lincoln's Peace, The Struggle to End the American Civil War, published by Knopf. The LA Times called Lincoln's Peace one of the 10 books we're looking forward to reading in 2025, and the book has been featured in the New Yorker and the Wall Street Journal. He's also the author of Final Freedom, The Civil War, The Abolition of Slavery and the 13th Amendment, which was the finalist for the Lincoln Prize and was used as the basis for the screenplay of Steven Spielberg's 2012 film, Lincoln. His writings have appeared in the Chicago Tribune, the New York Times, Politico, and the Washington Post. He is a distinguished lecturer for the Organization of American Historians, and he serves on the board of editors of the Journal of American Constitutional History. From 2004 to 2007, he was a member of Brown University's Steering Committee on Slavery and Justice. He received his PhD and BA, AB, from Harvard University, which we will not hold against him. So, okay. Give the books back to you. Have them. The run of show is that I will ask 4 questions of the panelists. Each of them will try to answer the questions. And then we think about 9:35 at this point, we'll stop for Q&A. Given the capacity of the room, we'll ask one of the fabulous people who work at Watson to pass around a microphone rather than you standing up and trying to get out of the seats. So without further ado, I'm going to switch gears and ask them first question. Just for the panelists, we are live mic'd on the panel the whole time. Just so you know. We will rotate who goes first in answering. So the first question for both of our esteemed faculty members. Can you identify a president from history who sought to expand executive power relative to the size and scope of the federal government at the time in the ways that we have seen President Trump try to do so in his first and second terms? Is he unique in his actions in this regard? We'll start with Professor Brettschneider, and then we'll go with Professor Vorenberg.
I do think that in some instances, is this mic on? You can hear me fine? Yeah. Okay, great. That in some instances, I'm going to argue that certainly what President Trump is doing right now is not only unique, but is a unique kind of threat to American democracy. So the issue isn't just big versus small. It's about using the size and power of the presidency itself to realize a kind of danger that was noticed early on. But it's not totally unprecedented. That's the thesis of this book, The Presidents and the People, 5 Leaders Who Threatened Democracy and the Citizens Who Fought to Defend It. And I'm going to focus on one of these threats to democracy, somebody who actually is often regarded as a hero, and that's John Adams. He has his own miniseries. Paul Giamatti plays him. He's quite good. I see why people like Adams through Giamatti, but the Adams that I'm going to give you is a very different kind of Adams. But there's also a hopeful part of my story that, and I'm going to talk about a pattern too. Adams I'll go in depth about, but I'll talk about his example as a kind of pattern of the danger of the presidency. And without undercutting how serious that danger is, there's a kind of hope in my story too. And I'm not going to leave you feeling despondent, because as threatening as the American presidency is internally to American democracy itself, a point realized at the founding, and I'll mention that recognition, there is also a way in which, although the traditional checks and balances, the Congress through impeachment, the Supreme Court, have often not only not checked the president, but have made things worse, there has been a check that the framers didn't really consider that has worked. And that's citizens themselves seeing these threats for what they are and then pushing back. So first, the threat. Patrick Henry, who you've all heard of, he said, of course, give me liberty or give me death, is less understood for his role during in the aftermath of the Constitutional Convention. At that moment, what he warned was, do not ratify this Constitution. And Henry's point was that the framers have assumed a person in the office of the presidency who is going to be a person of virtue. And specifically, they were thinking about George Washington. And his point was, things will function fine with Washington. But what if you have not a person of virtue, but a bad president? And then he uses a phrase that's going to resonate. He actually says, what if you not only have a bad president, but a criminal president? And I'll tell you exactly what he says about a criminal president. He says, what's going to happen is that this person is going to start with small crimes, and they're going to realize that the powers of the presidency, including the pardon power, which are supposed to be benign, are so dangerous in the wrong hands that they can be used, for instance, to pardon co-conspirators. And with other anti-federalists, he said, this power is just going to get worse and worse because the person will realize that these supposed checks, the Congress and the court, aren't going to work in the face of a devoted criminal president. And this is what's going to happen. He says, let's start with small crimes. They'll realize there's no check. They will start to get even more grand in their ambitions until they will, and this is his phrase, crown him. Once that person realizes there's no check, they won't hesitate to crown himself a monarch. And in fact, he says what this person's going to say, here's the quote, away with your president, he declared. We shall have a king. In other words, Henry's warning is this thing is so vast, the power of the presidency. In the good hands, fine, no problem. In the wrong hands, the checks and balances just won't work. And, in Washington, much as he predicted, actually, in George Washington's presidency, in the second inaugural, he is not only a person of virtue, but he defines the office in this way that really is an office subservient to the rule of law. In the second inaugural, for instance, he says, Look, I just took the oath of office. It requires in Article 2, word for word, that I say that I'm going to preserve, protect, and defend the Constitution, the only oath outlined in the Constitution. And then he says, this is the shortest ever given, actually, this second inaugural, if I violate it, I want the people assembled here to subject me to upbraidings, in other words, criticisms. And if I really violate it, I want you to subject me to constitutional punishment. In other words, the office is above the person. And he outlines that. So far, so good, but his vice president is a very different story. And once John Adams takes power in 1798, he signs a series of laws that are aimed at nothing less than shutting down the opposition party. And I'm going to focus in particular on one of these laws. I'll mention some of the others too. But in 1798, he signs the Sedition Act. Now, just to show you how dangerous the Sedition Act is, in its text, it makes it a crime to criticize the President of the United States. And now this is where all the American history that I know you took from Gordon Wood and others is going to come in. But it doesn't make it a crime to criticize the Vice President. Now, why in 1798 would you want to design a law? And wow, no, I love this brown crowd. Everybody's with me. I don't have to explain, but I will explain that the Vice President of the United States is a member of a different party, the opposition, the Democratic Republicans. It's Thomas Jefferson. The law is designed in order to shut down the opposition. So why have historians missed how this was a law designed to shut down the opposition party? One is because for a long time, the number of prosecutions was thought to be 36. And we now know through Colin Bird and other research that it's actually more like 126. And this vast number of prosecutions was all in the spirit of the text of the laws. It was meant to shut down the opposition. It included a sitting congressman, Matthew Lyons. It also included many of the newspaper editors who were criticizing Adams' policy. And what about, okay, you would say, it's clearly unconstitutional. The Congress has already ratified the First Amendment, which makes it so that Congress can't pass any law abridging the freedom of speech. Go to the Supreme Court and that'll be the end of it. But the dynamic of the time, and you'll see the parallel here, is that the Congress is controlled by the Federalist Party, Adams' party, and the court, although justices, as we know, are not officially partisan, is very much in the corner, not just of the Federalist Party, but of the Sedition Act. In fact, Samuel Chase, the most prominent Supreme Court justice of the time, not only lobbies for the law, but he makes it a point of going and sitting on the trial of one of the most important editors at the time who's being prosecuted for criticizing Adams, and that's Thomas Cooper. So this is not a moment in which the traditional checks and balances, needless to say, there's no way you're going to get impeachment with the Federalist Party in power, right? I mean, it resembles the current moment in a lot of ways. You're not going to get the court striking it down. In fact, the court's lobbied for it and is taking the step of sitting on the trial level court to try to stop this. So what happens? Because there is a good part of the story. The traditional checks don't work, but what Patrick Henry didn't anticipate is that citizens themselves take matters into their own hands. And specifically, Cooper uses his own trial as a way of putting Adams on trial. And he uses that by publishing the transcripts to try to illustrate the idea that this president has taken an office that's supposed to be about the rule of law and turned it into a kind of tyranny. Now, Adams himself, in his philosophy, is a noted constitutional thinker. In fact, our panel, The Rule of Law, he talks about the rule of law, but his idea is very different. It's a notion of the rule of law under a kind of quasi-constitutional monarchy, that the president is like a monarch. There even is a moment in the Sedition Act, to show you the parallels here, where an editor named Duane uncovers a plot that is actually taking place on the floor of the Senate, which is that there's a bill, and this is going to remind you very much of January 6th. In fact, I don't have evidence that John Eastman took it from here, but it certainly resembles it. The plot was that members of Congress would form a committee that would block the certification by the vice president, after all, it's Jefferson, of electoral votes in the instance in which Adams lost. And what would that do? It would, under the Constitution, throw things to the House of Representatives, where the House votes state by state, and the Federalists had the votes to win. So what does Duane get in response to publishing this scandal, and the bill is withdrawn and never really moves anywhere after its light of day is shown, he's prosecuted under the Sedition Act. It is nothing less than the shutdown of the opposition party. But Cooper and the other editors use these trials as a way of putting Adams on trial. And in 1800, presidents don't campaign in the way that they campaign now. Jefferson gave like one speech. It doesn't go very well. So there's a kind of void. And into that void, these editors step. And they turn the election of 1800 into a kind of referendum on the question of whether or not we're going to have a monarchical constitution, which is how Adams in his writings explicitly understood it, or a democratic constitution that includes the right to criticize a president on a regular basis in the way that you see it on Saturday Night Live, that it is not just a right of free speech, but a right to dissent. That's the argument of the editors. And eventually Madison and Jefferson championed that. What's important about these protests is not just that they're, principled, but it's that they work, that they use this election, they elect Jefferson. And so when Jefferson says we're all Federalists, we're all Republicans, the real meaning of that is I'm going to allow the Sedition Act to expire. We're not going to shut down free speech. Now, Jefferson, as many of us know, is far from a perfect person. He's a hypocrite in many ways, including here, where although publicly he proclaims allegiance to the editor's idea of a right to dissent, he does secretly seek the prosecution of some of his opponents through writing letters, for instance, to allies who are governors throughout the state. But in Madison, you have not just a philosophical vindication of this idea that the presidency has to be subject to the sovereignty of the people, and as Alexander Meiklejohn taught us two centuries later, that means that the people can criticize the president. That's core to democracy. Madison celebrates that, not only in 1800 in his report on the Sedition Act, but also as president. When there are calls for the shutdown of the opposition party, this time the Federalists, from his own Democratic Republicans, he not only refuses, but he brings in the Thomas Cooper of that time, an editor named Hanson, to the White House and celebrates him as a dissenter and really speaks out and quells the violence that's going on against, this time, the Federalists. He had an easy out. In 1812, it wasn't a quasi-war as there was in 1798. It's a real war. And he could have said, this is a different circumstance. So you see the pattern, and I won't go into the other stories now, except to say that pattern repeats. I'm with the world's expert, and that is no exaggeration, on Lincoln. And one of the stories, and I'm humbled to have gotten to talk to Michael about this, and there were no drastic errors, thankfully, in that chapter. But the second cluster is the story of Frederick Douglass, who I call the true founder of American democracy. I'm going to stop you there
and let you jump back in to that story.
I got my first. First of five.
What I would like to do is go, Michael, to question number 2, and then if you want to go respond to Corey's remarks again. So question number 2 is, what is the acceptable scope of powers legally afforded to a president during wartime? Does history show us any good examples of how presidents have sought to end wars? And I'm going to add something else to that. So if we interpret the current use of the justification of President Trump's orders on deportation, for example, and in revoking visas, sort of the Alien Act, the War Act, just basically the national security premise. And he's using also an emergency economic premise for the tariffs as well. So thinking about the extension of that presidential power, that's the sort of impetus for that question.
Sure. Thank you all for coming. And let me address the question that's really been all on our minds this morning. And that is, of course, Greenland. Will it be part of the United States by the end of the day? So I actually want to go back to question 1 just briefly, then I will take up question 2. And I'm not entirely joking about Greenland, because I will end up talking about Lincoln. My credentials maybe have been overstated on Lincoln, but I want to talk about a few other presidents first. The first question had to do with the power of the president in expanding the government. Where have we seen this? To Corey, who just spoke about Jefferson, I might ask, well, what about the Louisiana Purchase? And that is an incredible moment of presidential power to expand the territory of the country in a moment where many historians criticize the legitimacy of the act and also see it as, one step towards expansion. And if you learn these things in grade school, you might call it part of manifest destiny. Now, for the two people in the room who actually sat through the entirety of President Trump's most recent inaugural, because I find that very few people listen to the whole thing, you will know that he actually invokes manifest destiny by name as a very good thing, whereas we tend to learn it in school critically. And he actually says it in his way deliberately, as this is the kind of America that we need. So there's Jefferson and the Louisiana Purchase, which is a major expansion and to which slavery is deeply involved. I'm sorry that Corey got cut off before we talked about Frederick Douglass, but we will, I promise, we will talk about Frederick Douglass.
I was moving the conversation along.
No, I'm just kidding, Wendy. I know. We will come back to Douglass. On that vein, though, of presidential power and expansion, I want to spend just a moment on James K. Polk, because that is quite relevant, and then I will come back to this issue of ending wars. So Polk, is often rated by historians as one of the best presidents, and this has to do with he makes a list of what he's going to do, and then he actually checks these things off the list. So the beginning of the U.S.-Mexican War begins with a lie that everyone knows is a lie, where Polk says that the U.S. has been invaded by Mexicans, and that then becomes the pretext for the war with Mexico. So the idea that a president says that we are under invasion, and this then becomes the pretext for an extraordinary expansion of war, that should sound kind of familiar and speak to this issue of executive orders. The deportation of Venezuelans is, of course, well, I say of course, but maybe you don't know this, is done under the pretext of the U.S. is currently under invasion or predatory incursion. These are both words that come from the Alien Enemies Act, which is a big part of Corey's book, and which we will talk about, I'm sure. Are we under invasion, right? Well, that's actually a question that was asked in Congress when Polk claimed that we were under invasion. And one of the people asking this question is a young congressman from Illinois, Abraham Lincoln, who talks about, show me the spot. These come known as the spot resolution. Show me the spot where we have been invaded. And so Lincoln at that time is a Whig, which is to say an anti-Democrat. Polk is a Democrat of the Andrew Jackson variety. So we have there a congressman willing to challenge a president who says we are under invasion. You might notice the contrast to today, the silence, the deafening silence out of Congress on this issue of invasion. So I just thought I would mention that. That war begins, the Mexican War, with a congressional declaration. It ends with a treaty signed by Congress. Now, this is actually, regardless of how one feels about the war and its justification, how wars are supposed to begin and end under the U.S. Constitution. We no longer begin and end these wars, and we haven't done that since in this way since World War II. And actually, the Civil War, now I come to Lincoln, is more like that our modern wars than our prior war. There is no congressional declaration of war. Later on in the war, while the war is going on, people mention this, and so they go back and they find an appropriation bill by Congress, and they say, let's call that a declaration of war. So they kind of invent one. The power to declare war is supposed to lie with Congress. Of course, it ends up being with the president over and over again, and that happened with Lincoln, who is the one who moves us towards war. And Congress is not in session, so it's defensible. For me, though, and this is a huge part of the book I've written about, it's called Lincoln's Peace, The Struggle to End the War, is arguably the greatest power, but it's unwritten, and it's not in the Constitution, is the power to end a war. So once a war begins, once you declare that a country is at war, how do you end it? Because we haven't ended a war with a treaty for a long time. Right now, the U.S. has declared war, or the president has declared war, not just against a number of non-state actors, against terrorist groups. How do those powers end, right? What president whose powers have expanded by declaring war would drop that power, would end the war? And so we've had these various endpoints. George W. Bush, sort of, with his mission accomplished speech in 2003, but then the war continues for 8 years in Iraq. Obama, another declaration, 2011, also saying that the war in Iraq is over. Private contractors remain. So this this question of how does a war end is crucial. And that is crucial, actually, the more relevant precedents are not from the US, but from Europe in the 1940s. And because Carl Schmitt, the lead theorist behind the Third Reich, is basically arguing that there are these states of exception. I could put it in German if I could pronounce it. But the states of exception are these states of exception where the leader has extraordinary powers. And it's that state of exception, sometimes called the state of emergency, that then legitimizes such that Hitler's grasp of power is entirely constitutional. That's crucial to that administration through this state of exception. So when do we have a state of exception? And that's where we are now. We have these EOs, these executive orders that are being constructed as states of exception. An exception being, for example, that we are under invasion. And then there's other exceptions that have been invoked for tariffs. Why do we have tariffs? Because there's certain things going on. So the relevance here of history is great, and it isn't just American history.
Thank you. Corey, we'll start with you. The balance of power between the executive and the federal judiciary has shifted back and forth over the course of history, American history. What has brought us to this point in time where a presidential administration is repeatedly challenging the authority of the federal courts to limit their actions, or I would say maybe scope of authority? Or is this not as new as we think?
The usual story that we tell about judicial review and constitutional law is that in a case involving an appointment of, I won't go into the details, but of an Adams appointee, Marbury, that the court declared the power of judicial review. And it's a massive power. And the power of judicial review is the power to take the Constitution, hold it up against any presidential action or legislation, and declare it unconstitutional. Now, that's an enormous power. And the idea of the framers is supposed to be that power of judicial review is good because it's the bulwark of the Constitution. It protects it. But part of the argument of the book is that the judiciary, and including the Supreme Court, throughout American history, the moments that we've glorified it have been less important, I argue, than we've thought, and that there have been many moments, like the one that I described, in which the court has actually aided in the destruction of the American democratic idea of the Constitution. And part of the idea of the book is that there really are two constitutions, one authoritarian and one democratic. And they've battled it out throughout. Now, you've already heard about some of the authoritarian constitution. That's the story of John Adams, a kind of monarchical idea that includes the ability to shut down sedition, the same way that a king can. And you heard about the democratic idea, the origin of it. In particular, the editors who fought back and read the Constitution the way Alexander Meiklejohn would much later, as a democratic right to dissent. And the court isn't the hero there, it's the citizenry. Now, to move to the second story that Michael's mentioned or alluded to about Frederick Douglass, the court there not only acts in a bad way, but it is the most evil decision in American history. The Dred Scott decision denies Black Americans any legal status, legal personhood under the American Constitution. And in that instance, it's at the behest of a president. President Buchanan, while pretending to be neutral and saying this normal story that we hear, it's the court that decides on the Constitution, lobbies for the Dred Scott decision. Frederick Douglass suspected this, and we now know that he was right. So how did we recover in that instance the democratic idea? It was, again, and you see the pattern here, through a citizen. And what Douglass did was teach us how to read the American Constitution. He says, for instance, the preamble says, "We the people, not we the white people." The Constitution bans the so-called corruption of blood, inheriting the crimes of parents in the next generation. What is that but an anti-slavery principle? And he goes further and says, before Lincoln thinks about it in this way, Lincoln is thinking about similar things, but not in this way, the Declaration of Independence in its claim of equality, which he reads as a universal equality, has to be read throughout the American Constitution. And the story of the book is not that the court recovers the democracy, but that Douglass, through his democratic constitutional constituency, prevails on Lincoln to some degree, not fully, and really President Grant, who in the establishment of the Department of Justice creates a department that prosecutes more than 1,000 white terrorists throughout the country. in the use of the 15th Amendment in its second section in particular to pass the enforcement acts to enforce civil rights for the first time, including voting rights in this country. The election of 1868 had the murder of many, many Black Americans throughout the country, and finally, Grant vindicates that. So that's my story. It's not the court. Now, what about Brown versus Board of Ed? Even there, I want to say, it's Thurgood Marshall who litigates the case, plays a role, but much earlier during the Truman Civil Rights Committee, where they outline a way of recovering the democratic idea. And many of our best decisions that I taught for years at Brown as really heroic decisions, one of the most famous being U.S. versus Nixon, 8-0, saying we thought that a president was not above the law, turns out not to mean that anymore. After the immunity case, which came out actually the day after this book, unfortunately, perfectly timed. I mean, it was like the court was working with my publicist or something. Say, for the first time in American history, in a really lawless decision, one not bound in the text of the Constitution or in precedent, that a president, at least when it comes to his official duties, the most dangerous, by the way, has presumptive immunity. And that's what Trump used to get out of the January 6th case. That's what has emboldened so much to go to the real question of the threat right now that we're seeing to democracy, declaring not just a president, sitting president, which itself was controversial. Adams thought it. People like James Wilson thought the president's not above the law. There was a debate about sitting presidents. There never was a debate about former presidents. In fact, Ford's pardon of Nixon assumes there's not immunity for former presidents. And yet in declaring that, they've really incentivized so much of the really assault on democracy that echoes each of these 5 cases that you're seeing on a day-to-day basis.
Thank you. Michael?
Yes, I'm just going to touch on 2 big topics because I think they are likely to come up, and I hope they will come up in the Q&A. And one is habeas corpus, and the second is birthright citizenship. But let me put these in the historical context of both. I'll use Lincoln for both. And they also, both of these issues, they come up in terms of what Corey was just talking about. So first, let me actually talk about birthright citizenship because it flows more naturally from where Corey just was. When the Dred Scott decision is issued, the most famous part of it is the denial of citizenship to all Black people, free and enslaved. And that's a remarkable thing for all sorts of reasons, not least of which is the fact that there were Black people in the North who had been citizens for a long time. There were Black men who were voting in the North. So to say that Black people had, or the phrase uses, Negroes had no rights, that whites need respect, it was a remarkable statement. But in response to this, and this gets to Corey's idea that there's this democratic alternative, right? There's a dissent. Lincoln, in a speech, says he does not accept the Dred Scott decision as settled doctrine. So he's pointing the way to the fact that a new court could end up overturning it or some other way could overturn it. Frederick Douglass, of course, denounces it. Now we get into the Civil War, and essentially Dred Scott is overturned by a series of kind of ground level actions. A crucial figure here is a Black sailor, almost unknown, named David Celsey, who's a freeborn African American. And this whole thing is set up as a case where he's stopped by Treasury officials and told that he's not allowed to pilot his ship around New Jersey. Why? Because he doesn't have a license. Why doesn't he have a license? Because he's not a citizen. Now, this is a complete setup because they want the issue of citizenship before the Attorney General. And so the Attorney General writes in response in 1862 an opinion saying that David Celsey is in fact a citizen because he was born in the United States. This is known as the Bates Opinion of 1862. And in this opinion, which is cited a lot on both sides of the current debate about birthright citizenship, it's the first time, it's well before the 14th Amendment or the Civil Rights Act of 66, both of which talk about birthright citizenship. It's the Attorney General of the U.S., and therefore it has standing in law, who says that if you are freeborn in the country, you are a citizen. Now, if you're slave-born, he leaves that vague, but let's just focus on freeborn. The other part of this opinion I want to say very quickly is he does take up the question of, well, what about citizen by parentage as an alternative? And he says this, citizenship is always original with the child. It is always original with the child. You cannot make it heritable. That's it. That's done. So this idea that somehow you might inherit the illegal status of your parents, if the originalists go to this, they're in trouble. And some of the originalists, like Randy Barnett, have invoked the Bates opinion, and I've never seen, well, I'd say it's an incredible job of cherry picking, because he invokes the Bates opinion for one reason, but ignores that crucial statement that you simply cannot look to the parents on citizenship. The question is the child born here? It's actually a kind of clean slate idea. Habeas corpus. A few days ago, you'll know that maybe you don't. You heard the Secretary of Homeland Security was asked in a hearing by Senator Hassan, a Brown University graduate, if she would please expound on habeas corpus. And Kristi Noem responded by saying, I'm not going to get this quite right, but she began by saying, it is the right of a president to deport people, And then she began to say, and it has been done by, and then she said Lincoln, but then Senator Hassan cut her off. Now, I wish she hadn't, just because I wanted to know what she was going to say about Lincoln. But I know what she was going to say about Lincoln. So what did Hassan say? Hassan then pointed out to her the correct definition of habeas corpus, which had been turned on its head. First of all, it's not a right the president has. The president doesn't have rights. The president uses powers. It's the right of ordinary people, of course, to avoid precisely, to have legal recourse precisely to what President Trump has been doing. But what was Noem going to say about Lincoln? What she was going to talk about was the Merryman case of 1861. No question about it, because that's when Lincoln proclaimed the suspension of habeas corpus in a very specific area, the train line between Philadelphia and Washington, because Washington was surrounded by hostile people during the beginning of the Civil War. And in that suspension, John Merryman, a Maryland man who had plotted to burn bridges, is arrested, imprisoned. The Chief Justice, in an independent and in re decision, that's Taney, same justice as Dred Scott, issues an opinion saying that this is a violation of the Constitution. One of the things he says is that suspension of habeas must be done by Congress, not the president. He may be right about that. Maybe Corey has an opinion on that. And so maybe Lincoln was on bad ground there. Congress wasn't in session. For Congress to be brought into session would take a while. It did take a while. Eventually, Congress did approve what Lincoln had done retroactively. And so Congress essentially approves that part. But Taney's opinion goes further and talks, it's a very powerful statement about civil liberties in wartime, and says that Lincoln has violated them. And in truth, Lincoln stretched, if not broke the law by doing this. And we are stuck with this. And this is actually part of Corey's book. So we may end up talking about this too. This question of, did Lincoln not just stretch, but break the law when he imprisoned Merryman? And that's a really relevant decision. I'll finish with this. The crucial defense is that Lincoln has said the country is in a time of turmoil and insurrection. Was it? So we today look back and we say, yeah, 11 states had seceded. There'd been a shelling of Fort Sumter. There was a Confederate army. We say all these things are true. But I got to tell you, there were many people in the country who said, no, this isn't such a big deal. If you just let the South have their nation, let them go, all of this goes away, which is probably true. And Lincoln refuses to do that. He says the Union must stay intact. We today say, well, of course he did that. But did he have to do that? I certainly think he had to. But there's nothing in the Constitution that actually says that. Nor is there anything clearly in the Constitution itself that says that secession is unconstitutional. I am on dangerous ground by saying this, but it would take a court decision after the Civil War to do that. And the Lincoln administration and the administration that follows, they don't really want to bring this secession as legal case to the courts because they're worried about it. So I'll just put that out there. These are two issues that I hope will come up, habeas and the birthright citizenship. Both, of course, have been in the news quite a bit.
Can I ask, I'm going to go off script. Corey, can I ask you to respond on habeas corpus? And also, let's talk about the threat of California. You know, Texas decided it was going to secede under Biden. Now, California, those of you from California in the room, now your auto emission standards have been knocked down. So, and California's threatening to go. It's the 7th largest economy, I think, or the 6th in the world. So, could you talk about that? And then I think I will turn to some Q&A. We have permission to go 5 minutes over. So I don't know if you have to go somewhere, you can get up and leave, but we do have permission to go 5 minutes over. But if you're really hungry, get out the door at 10, because that's when breakfast is. So Corey, and then we'll take some Q&A.
I mean, it's another, the book is really, this book is unfortunately relevant. That's how I've been describing it. I wish it was just a history book that had nothing to do with the current moment.
Or a history, not just a history.
Yeah, exactly. Right, exactly. But it is relevant in too many ways, and one of the most specific ways, which Mike alluded to, is the 1798 law, not the Sedition Act, but the Enemy Aliens Act. And on this podcast that I've now launched, it's about 14 weeks in, we talk about the cases of the week, but we also have guests who have expertise, and thankfully Mike has told me he's going to be on. But we've also had another Brown grad, who I think you might have introduced me to, Wendy, Mike Zamore, who's the policy director now of the ACLU. And the ACLU is doing so many of these cases, and one of the most important ones that they're doing is the Khalil case. Khalil is being held in detention in Louisiana, and for those who don't know, he's married to an American citizen, was a graduate student at Columbia University, and was detained by the Trump administration. And they're not claiming that he committed a crime. It's really in response to his political views and his viewpoint. And they're claiming that under a law called the INA, that speech adverse to foreign policy is the basis for deportation. Now, how can that be? Because the First Amendment just says that Congress shall make no law abridging of freedom of speech. It's a limit on government, and specifically the federal government, exactly in this kind of case. And it's a right of persons, the way that it's always been understood. So the way they're arguing it is that under the Sedition Act was allowed to expire, and so was a law called the Enemy Friends Act. But one law that remains on the books from this Adams period that I was talking about is the 1798 Enemy Aliens Act. And what the Enemy Aliens Act says that in cases of insurrection or invasion, that essentially you have no rights, that habeas corpus is revoked. That's the argument. Now, is there an invasion? Why do they have to say that there is? Because the text of the law says that you need an invasion in this kind of
or
case.
a predatory incursion. It's a wonderful phrase, predatory incursion.
So their argument is that basically in cases of enemy nations, in the Venezuelan cases, I should say, but it's closely related to the argument that they're making in Khalil, that the danger here means that INA can be used to even deprive free speech. Now, they're going further in the Venezuelan cases, which Zamore was also involved in. In the case of a plane, for instance, that was ordered back by a judge, why could they just resist? Well, they're claiming that there is no right to due process at all, not only not a right to the First Amendment, but in the case of enemy aliens, that habeas corpus there really has been revoked. I guess to be specific, in the Khalil case, they're saying there's no free speech right because of this INA, but in the Venezuelan case, that there's not even a right to due process. So look, 1798 is very much with us, both in the prosecution for speech, in the Khalil case, and in the revoking, they're claiming, of due process even. Just to be clear, due process means the right to be in front of a judge to have to show that you really are, for instance, from Venezuela. And in one case, at least the case of a barber, it looks like they just got the wrong person and they won't return this person. So all of these laws, all these moments, that moment in particular that I talked about is extremely, unfortunately, relevant.
But you want,
can I just say something about due process quickly? Because this is also a point that Corey has made on YouTube and many other places, but it's really important we understand due process, and in the 14th Amendment at least, which is it applies to persons, not citizens. It applies to the broad category of persons. In the 14th Amendment, there's a Privileges and Immunities Clause, which applies arguably to citizens, but there's unquestionably about due process applies to persons, period. And that's really important because you often hear this misstated by officials and others. that, well, they're not citizens, they don't get due process rights. That's irrelevant. And I think I'm just going to put that out there. It's just this truth, right? So I'll just mention that as well.
I do want to point to a Brown connection before we open it up for Q&A. Jeremy Feigenbaum, who I think took either your course or I know he took a few with me. So Jeremy Feigenbaum is the Solicitor General of New Jersey, and he is a Brown alum, went to Harvard Law, clerked for District Court Judge Annalena Kagan when she was appeals court judge. She clerked for Kagan on the Supreme Court. He was one of the primary lawyers arguing the 14th Amendment case in the Supreme Court last week. So that's just sort of how far the reach of Brown goes on this particular birthright. He was one of the lead solicitors arguing the case in the Supreme Court. So no pressure on anybody who's not yet graduated if you went to Brown. But so I want to open it up for questions. I'm going to ask, where did our folks go?
We can always repeat questions.
Yeah, we can always repeat questions. Yeah, that's right. So if you want to just answer, raise your hand. And I like to go back and forth. So gentleman on the left and then gentleman on the right. Yeah, sir.
Great, thank you very much for the event. My name is Vincent. I'm a Brown alum over 15, and I'm German.
There's a mic right there if you want to take it.
Oh, perfect. You heard what I just said, right? Okay. So my question is, in the history of Germany, it's very easy to identify the red lines in retrospect when democracy has been broken. What are the red lines in American democracy that might be broken in the near future? That is my question, and in return, I will help with German pronunciation.
I'm going to take it.
Okay. I think we're getting the better deal. Thank you.
Do you want me to go?
Yeah, why don't you? Yeah, that's a great question.
It is a great question, and I have an unfortunate answer, which is I think we've already crossed them in at least multiple instances, but I'll mention a couple. One is, and I just want to emphasize this, so the use of the Enemy Aliens Act, again, the point is not just that there's discussion about revoking habeas corpus, which there is, and Stephen Miller has been talking about this in the media, but their argument really is, unfortunately, that the 1798 Alien Enemies Act does revoke habeas corpus in at least some instances, meaning there is no right to appear before a judge, no right to due process. So the red line was when Judge Boasberg said in this ACLU case, turn the plane back. You didn't show me that these are actually even Venezuelans, and ordered, now said it not on paper, but through oral order. I don't think that makes a difference. Turn it back. And they didn't do it. Now, Boasberg is saying we need to have contempt hearings because you disobeyed a judicial order. The administration isn't backing down. And actually, the appeals court is now hearing this. We don't know what's going to happen. This is a red line because they just said no. The court said due process. They said no due process, and they just ignored it. Now, when you see the power of the presidency here compared to the power of the court, you see why the court is often regarded as the weakest branch, because it doesn't have the military, it doesn't have a police force. It doesn't even have the U.S. Marshals. The U.S. Marshals, who are charged with carrying out contempt orders, work for the executive branch. So who are they going to follow in an instance in which the contempt actually is ordered? It's one of the things I'm sure that is really being deliberated by the appeals court and will be. On the congressional side, we can talk about this, but Doge went into the Treasury Department and found out where now the power of the purse is supposed to be, and all of Professor Schiller's students know this, supposed to be with Congress. But actually, Elon Musk figured out the actual purse, the physical purse, is like a computer in the Treasury Department. And they use that to do various things, including impound funds, refuse to spend them. They're destroying, of course, agencies created by Congress. They are usurping the power. Now, add it all up. The meaning of what political scientists call a self-coup, usually when they're talking about Latin America, isn't a military coup, but is where the president of the United States destroys the other branches and assumes dictatorial power. Now, it hasn't completely succeeded. I think that we're in the midst of a fight. Thankfully, we're in a constitutional crisis. But the more worrying idea is when the crisis is gone and the coup succeeds. So that's how I've been describing it on the Oath in the Office every week. And I'm not doing it by myself. I'm doing it with the people who know, including Zamor, who's, that's who's representing a lot of these cases, or those who are experts when it comes to Congress. And we can see this coup going on. Now, if we were describing a Latin American country, it would be described that way. But because we're in our own country, it's very hard to see it, to go to your question. But it is happening right now, no question.
So just as a follow-up, if we go back to 2017 and the first months of the Trump administration, which seems like a distant memory, you will remember something that was called the Muslim ban for immigration. The court, of course, ruled that that was unconstitutional, but then basically, like courts often do, gave instructions on how to make it constitutional. And so that's what the administration did. They rewrote the ban so that it could pass constitutional muster. Now, I mention that because however we feel about the first or second version of the ban, or third, what happened there was a give and take between the president and the Supreme Court, which arguably is how things are supposed to work. Today, I don't know of an instance where a federal court, including the Supreme Court, has said something that against the president that they've done is unconstitutional, that's led to a reaction, that's led to a modification. And in fact, all it's led to is a statement that says it doesn't matter. Now, am I wrong about that? I can't think of a qualifying thing. So that to me is evidence of a crossing of the red line. Because even under Trump 1.0, in that instance I gave, you have somebody who says, oh, we're actually going to take what the court says seriously. You still end up with a ban that's problematic, but at least they made a gesture towards saying what the court says matter. Now there's no gesture. It's just nothing. So that red line has been crossed in terms of the court. It's been crossed in other ways, but I'll stop there because I'm sure there's other questions.
Yeah.
Thank you. Right at the beginning, one of you gentlemen made a reference to the deafening silence from the Democratic Party. Yeah. And no offense to the gentleman who asked the first question, I see a terrifying similarity to the rise of Nazi Germany, where the leader takes over step by step by step, just takes more and more rights away from people. So I'm just wondering why you think the Democratic Party just isn't in an uproar on a daily basis. I would refer to him as Adolf Trump. I would say Adolf Trump today took away the right of students to go to Harvard. Adolf Trump took away the right of this and that. So I just wonder what your opinion might be.
So I'm going to jump in. It's a little bit more of my territory.
Thank you.
Congress and politics. So, and this was, I want to read my last question because it gets to your question. We didn't have time, maybe if they'll stick around for some food and coffee. But can you point to an episode in American history when individual civil liberties were constrained or denied by presidential action when the rule of law was seemingly intact and not being distorted by partisan politics? So the reason I wanted to ask that was when we think about the Korematsu decision and FDR, who's like Lincoln, sort of this elevated hero, but the internment of the Japanese was a violation of human rights and certainly a violation of the Constitution. And McCarthy, Eisenhower was a pretty decent president, but let McCarthy destroy people for starting in 1948, really, the same year that Truman issues the executive order to desegregate the armed forces. So you have the Republicans allow McCarthy and ride his coattails all the way, even after Edward R. Murrow's interview, right? All the way to 1956 with the Red Scare. We've seen parties capitulate, right? And the Republicans are capitulating to Trump now. The Democrats, there's two reasons. One is border security was overwhelmingly named as an issue by a vast majority of voters. It's not a winning issue for the Democrats now. And then inflation, which has come way down, and Trump seems to be making some decisions that are worrying people economically. The Democrats have always run, Bill Clinton, Barack Obama, in an economic crisis. They run and win when they focus on the economy and say, this is what we're going to do to fix it. That's how they win. They just can't jump up and down about this because too few people feel it right now. So I think that's one of the reasons. But the Republicans just passed a fairly big budget bill that includes an extension of the Trump tax cuts. And that's what the Republicans want. That's the only thing they want administratively. That's what they want to go home because the Republicans believe they can counter a lot of the anti-democracy language with "we cut your taxes." I don't know that's going to work for them, but that's what they think. And the Democrats don't want to be asymmetrically messaging. They don't want to be messaging about things that people aren't paying attention to right now. So that's one big reason why they're. The second is that there isn't, I will say this on tape, and to use an old phrase, there isn't really a charismatic leader in the wings that can message. But Bill Clinton didn't really emerge till a very overlong speech in 1988 at the convention, and people said it was too long. But he came out of sort of the wilderness. So did Obama. And I think we just don't know who that leader will be, and they don't have one right now. And that presents another problem. So they want to take advantage of messaging for the 26 elections. They want to focus on what usually wins them elections. But I will say this, one thing encourages me, and to this very point that I think Corey's book makes, and also Michael's work, is that we are seeing across the country, in I think a record amount of time, vocal opposition to the violation of civil liberties, particularly deportation cases, amongst Republican voters in Republican town hall meetings, with Republican senators and Republican House members. We have people getting up and saying, I'm Republican, voted for Donald Trump. I don't like what you're doing. I don't think this is America. It is also about veterans cuts and Social Security, but it's visceral. It's not a sea of Democratic-looking voters in these town halls. It's people who say, I get the border, I get the southern border. I don't get, kidnapping somebody in the middle of the night and sending them to some prison in El Salvador. That I don't get. That's not what I think we should be doing. So the Republicans in the House are feeling it. And so that they're quiet now, they get their tax bill, they want to change the subject. Does that mean they will start to sort of be more aggressively against the president? It's unclear, but that's why the Democrats, and there will be nothing more effective than continuous vocal opposition to these most extreme measures by Republican voters and everything at the local level. So Democrats can do this too, but it has to be quote unquote bipartisan. And remember, polarization. I can't even, it makes me nuts how polarization is sort of the go-to everything. Just as in the Civil War, you just said, a lot of people said, all right, let the South go. Who cares? We can do without it. Or Ross Perot in 1992. Who cares about, Arkansas, right? There are a lot of people who aren't caring now, who don't see the big picture, but they are starting to show signs at the very lowest levels of caring a lot. And if you just say, well, they're Republicans and Trumpers, I'm not going to engage with them, then we miss an opportunity, sir, to do exactly what you suggest we need to do, which is to unify on the fundamental core principles that both Professor Brettschneider and Professor Vorenberg have discussed today. So that is, I think, what we would like to leave you with the message. And Michael will have, and there's another question and another, but so I would like to get this gentleman and then the lady. Can I call you a lady? And then we're gonna leave your question for after, because I understand my father said never get in the way of food for people. So you go, and then you go, and then we will cut it off, and you'll join us for breakfast.
You said we've already crossed the red line. The coup's already happening. The problem is, this party and its dysfunction. Isn't it broader? Don't we have a systemic problem here with our political system that one party can only spend and one party can, only reduce revenue? That's been going on our entire lives, really, since we left here 50 years ago, that we've now gotten to ourselves in this place where it doesn't seem to work. Can our political system be fixed so that we can actually make policy and not just performative policy?
So I'm going to hold. That's a very good question. Can we get your question too?
Sure. My question's really quick. Yale recently lost 3 of their, well-known professors to Canada.
Well, they left.
They
didn't get lost.
Yeah, they left. So I have 2 questions. One is...
One of them a Brown graduate?
Yes. Is Brown at risk of losing some of their brain trust? And the second question is Heather Cox Richardson a good gateway drug for people who don't have the ability to join in forums like this at a rarefied university? How do we get this kind of knowledge more widespread in America?
Invite Michael Vorenberg and Corey Brettschneider to your libraries, your communities, your groups. Spread the word to bring them there.
No, I've just got to, this is just asking for a plug. She's great, but I have to recommend a podcast called The Oath in the Office.
So Heather and I were graduate students together. Heather, let us all remember, is a history person, a historian, and she is a gateway drug. So to what? Like, where's that going? What's the next drug? I don't know. I'd like it, whatever it is. But so yeah, she's great, and I do think that she has become over the years very much. If you don't know who she is, she's easily found. She has a newsletter, and she's wonderful. So I think, and what she does that I think that's remarkable is she simply reports, as she says, she's a chronicler, right? And yes, she does have a political bias, it seems, but not really. I mean, it's just, this is what's going on. And why is that so shocking? And this speaks to the media and where we are in the media and the chilling effect of these things on the media. To your question earlier about the Democratic Party, there are Democrats all around the country and on this campus, and not just Democrats, others who are in vocal dissent, absolutely vocal dissent.
Rand Paul, Republican of Kentucky.
Right.
Big example, Republican of Kentucky.
Right. But
Big
how
dissent.
would we know, right? How would we know unless the media covers them, right? And the chilling effect on the media to cover is a major problem. Hitler has been raised, I guess I raised him, but then you raised him in the question. I want to say, I don't think that's the good comparison. Just the best comparison is Andrew Johnson. And for that, read my book. And Andrew Johnson, who is Lincoln's successor, but no Lincoln, the parallels between him and Trump are remarkable in personality. In background, they could not be more different. But in terms of this insecurity that leads to a pretend ego is fascinating. Now, the reason I bring this up in this context is that Johnson, what he'll end up doing in the midterm elections of 1866, believing that he's extraordinarily popular because he is self-identified as a populist and all these other things, is he goes on a speaking tour, which the president never does. And Corey mentioned this before, it was indecorous of presidents of the time to leave the White House. And Johnson goes on a speaking tour, what he calls the swing around the circle. Never been done. He starts giving public rallies. And the more he gives it, the more he loves it. He loves the response. And it's like, it reminds me when Trump first became president in his first term, and he's like, I hate this governance stuff. Let me go back to the rallies, right? And so he's going on these rallies, the purpose of which are to denounce the 14th Amendment so that the ratifying conventions in the states will vote against the 14th Amendment. And he fails. And in the midterm of elections of 1866, overwhelmingly, which are really a referendum on the 14th Amendment, such an important amendment today, the people themselves, as Corey speaks to, the people themselves reject Andrew Johnson wholeheartedly on the constitutional issues. And they vote against him, and they vote for the congresspeople, the congressmen, and the 14th Amendment. And for that reason, the 14th Amendment is adopted. So I wanted to say that so we could end on something like a hopeful note, that there are these moments out there. Yeah. It is hard to imagine them. I agree with you. It is hard to imagine them. It's so easy to feel like the system is broken. We have felt like the system is broken before. I grew up in the midst of the Watergate crisis. I was surrounded by people who said, we're never getting it back. And but the system in some ways worked. And so that's worth remembering, and maybe we should take away.
I'd also like to say a final word about hope, and I think that all three of us are ending on that. And this is a book about hope, and part of it is being honest about the threat in American history of these 5 moments of presidents like Patrick Henry warned of using the power of the presidency to threaten some fundamental part of democracy, not just a one-off, but institutions like free speech or equal citizenship, or in the Nixon case, the rule of law itself. And one of my presidents, as Michael knows, is great minds think alike, is of course Andrew Johnson. But the hopeful part of the book is that Patrick Henry was wrong, Because there is this mechanism, and Wendy has talked about how it's happening right now. There is a mechanism of response, which is that when people see the cruelty in the instances of the shutdown of democracy, when it's not just an abstract political theory idea, but a person being seized, as has happened in many of these cases, they react throughout American history in moments in which it was at least as dire. Adams, the shutdown of the opposition party happened. 126 prosecutions. Buchanan, the denial of all rights to all Black Americans. Woodrow Wilson, then he's not the first white supremacist president, I say, but he is certainly the first white nationalist president, spreading the ideas throughout the country. And of course, in the Nixon case, the criminality, I interviewed Daniel Ellsberg for the book, and so much of the criminality wasn't about Watergate, it was the shutdown of dissent, including the attempt to destroy Daniel Ellsberg and his allies. And yet we have recovered again and again. Now, the Nixon case is difficult because we recovered to some degree, but in many ways, the moment we're in is still that moment. It's the immunity case is a vindication of the idea that Nixon told us that a president, when the president does it, it's not illegal. So we are in the midst of that fight still, and in the midst of those other fights, which are recurring. And yet we've prevailed in the past, and I think that these meetings, this uprising that's beginning, shows that that citizens, it doesn't begin with public officials, it begins with citizens in all of the cases. These weren't elites, they were people, a formerly enslaved person, newspaper editors, people an anti-war activists, people who rose up. And that's, I think, what we're in the midst of. And that's the resilience of American democracy. Not the court, but citizens. And that's what we're about to see again, I believe.
Yeah, so I want to thank you so much, Professor Corey Brettschneider, Professor Michael Vorenberg, and all of you for attending.
Thank you all.